All right, good morning, everyone. Court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Yes, good morning, Judge Sue Upper, Leslie Basie, and Zach Witchell appearing for the State of Wisconsin.
Good morning, sir. Your name for the record, please.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value and return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments.
All right, the record should reflect that the individual known to this court as Darrell Brooks is present in person in custody in street clothes. He is wearing a suit, I believe a tie, can't quite see around the monitor, and a mask. Your objections noted for the record. The appearance, as I've just indicated, stands. I do want to advise the parties today that one of the jurors called in this morning and was not feeling well, and I did excuse that juror. So that will mean at the appropriate time, when the court selects the alternates by random lot, I will only be selecting 3. I believe that was juror number 35. All right. Anything preliminary before the jury's brought out for the continuation of testimony from the state?
Is the audio on, Your Honor?
No.
Okay, thank you.
All right. Sorry about that.
The only thing, housekeeping to clean up, Your Honor, is Exhibit 15, which was the victim map that we had first introduced through Detective Casey, and you admitted it subject to proof of all of the events that are depicted on the map. We believe we have now reached that point where it can be admitted in full. I do have a poster-sized copy of that exhibit that's also marked as Exhibit 15. So we have Exhibit 1 is the map of the downtown area. Exhibit 15 is the what we have termed the victim map, or the parade victim map. That's a hard copy of that as well, and then I have a third one that I'll be introducing later today or tomorrow. But we just wanted to clear up on 15 that all of the information on that map has now been testified to, Your Honor.
I did admit it subject to the full foundation. Any position on that, sir?
To it being admitted.
Yes, fully received. I had received it subject to foundation, and the state's set forth its position. Do you have any position on that?
Yeah, I object to it. I don't see the relevancy.
All right, your objection is noted, and Exhibit 15 is received. I believe I told the jury it was received subject to that foundation, but I will advise them that it's been received by the court when they come out today.
All right, and then one other housekeeping matter. Last week, I believe it may have even been on Thursday, we had a discussion with Mr. Brooks outside the presence of the jury in which several broad topics were discussed. One of them was Mr. Brooks had indicated he did not have a pretrial offer from the state. We would ask the record to reflect that afternoon we did provide him again with a written copy of our pretrial offer, and that was placed with his materials on the table. I just wanted that in the record, please.
I object to that. I don't. If it was with my paperwork, I haven't seen it.
It was specifically one of the papers, sir, that you left in the bullpen area that on the next morning, on Friday morning, I made a record of providing back to you. So it was provided to you twice.
Well, I haven't seen it.
You want to put the offer on the record, Attorney Opera?
Give me 1 second, Your Honor.
So what's the significance of it being on the record? If
So that you are fully aware of it, sir. It was provided to you, but you're indicating you haven't read it, so I want them to make a record of it. The significance would be, I suppose, if at any point you wanted to change your plea, you could do that based upon the pretrial offer.
Well, In any event, I accept for value and return for value that document whenever I see it.
Attorney Opper, go ahead.
Sorry, it's just taking me a second to retrieve it here, Your Honor.
Your Honor, this would be a perfect time to address the subject matter jurisdiction that has yet to be proven on the record and must be
Mr.
proven
Brooks,
by the prosecution.
we are not going to address that. I issued a written decision last week. If you disagree with that, then you can take that up to a higher court. But I issued a written decision. I'm not addressing that any further.
It has yet to be proven on record.
Mr. Brooks, my written decision is the decision of this court.
Has it
Attorney
been
Opper,
proven?
go ahead.
Has it been proven on record that you have subject matter jurisdiction? Because it has yet to be proven.
Mr. Brooks, your position is simply not correct as a matter of law. I explained that.
Then prove it
and
lawfully
I issued
by
the
law.
decision. You might be confusing subject matter jurisdiction with venue, which is why I commented on that last week.
Absolutely
and there
not.
has been evidence received regarding venue. So I'm going to turn back to Attorney Opper.
has nothing
She's
to
going
do
to make
with
a
venue,
record of
Your
the
Honor.
pretrial offer. I'd ask that you not interrupt. Thank you.
Your Honor, the offer that was dated July 5 of 2022 reads as follows. Plead to counts 1 through 67 in the information. The penalty enhancers on all counts will be struck. Counts 68 to 83 will be dismissed and read in. The state will recommend 6 consecutive life sentences on counts 1 through 6. The state will recommend unspecified prison on all other counts. The defense is free to argue. This pretrial offer was conveyed to his prior counsel on or about the July 5th date, and there in fact had been a earlier offer as well that had been relayed prior to the preliminary hearing or the filing of the information back in January of 2022 that had also been conveyed to his defense counsel at the time.
All right, thank you.
So why haven't I been informed of that?
All right, Mr. Brooks, that is not a topic we are going to take up any further. I just wanted the record to reflect that offer was conveyed to you.
It wasn't conveyed to me, Your Honor. This is the first time I'm hearing of it. So if it was conveyed to my former
It's
counsel,
not something I'm going to. It's not something I'm going to further address, sir, unless you indicate to me that you would like to take advantage of the pretrial offer by changing your pleas to either guilty or no contest to counts 1 through 67 and submit the appropriate paperwork. I'm guessing that's not what you want to do. So unless that paperwork were to be filed, then I'm going to continue with this trial as if you are exercising your right to a trial in this matter.
and in all respect, Your Honor, I don't think it's fair that you should assume what I want to do or not, or what I don't want to do.
I just need to make a record that that paperwork was provided, sir. We'll continue with the testimony today. I'm not going to take up subject matter jurisdiction. I've issued a written decision. Is there any other preliminary topic from either party?
Is
Mr. Brooks?
that decision verified proof that subject matter jurisdiction exists? Because it has yet to be proven on the record.
All right, your objection is noted. Please bring the jury out.
Your Honor, is that the answer?
Mr. Brooks, I issued a written decision. That's your answer.
And what's that? And what does the written decision entail?
So that was provided to you last week. I'm not going to
I
go through
accept
it
for
again.
value and return for value the document that I have not seen. What does it entail, Your Honor?
Sir, you were provided with a written copy. I'm not going to read it into the record at this point. It is part of the record. It's a final order
If
for
it's
purposes
part of the record,
appeal.
why can't it be read into the record right now?
It doesn't need to be read into the record, sir.
Is it
It's
verified
part of
proof
the
of?
record.
Is it verified proof of subject matter?
Mr. Brooks, I'm not answering that because it's not something that needs to be verified.
It
have a
has
mistaken
to be
belief.
verified
Right. Is
by
the
the
jury
prosecution.
I heard the thing come back.
Or is that a tacit agreement that you don't have to answer that question or verify proof of subject matter
Sir,
jurisdiction?
I have no such agreement with you, tacit or otherwise. So that's not how this operates. Again, just
So
because
would
you
it be
believe
proven?
the law requires, that doesn't make it true. All right, the jury's
Show me
coming out.
lawfully
All
law.
rise for the jury, please.
Show me by lawfully law that you have subject matter jurisdiction, because it hasn't been proven on the record. It has yet to be proven for the record. Let the record reflect that.
The record will not reflect that, and the jury will disregard the comments currently being made.
The record
just
should
made by
reflect that.
Mr. Brooks.
You have to put it on the record. Otherwise, that'd be tampering with the record. So at 8:40,
All right. Good morning, everyone. Please be seated.
tacit agreement at 8:40.
All right. Please disregard the most recent comment by
Tacit
Mr.
agreement
Brooks.
at
It's not
8:40.
evidence in this proceeding. All right. The statement call its next witness.
Thank you, Judge. The state calls Sean Backler.
Subject matter jurisdiction
Jury will disregard that last statement by Mr. Brooks.
has to be on the record.
The first thing I will ask you to do is to state your first and last names for the record and then spell each.
Sean Backler, S-E-A-N, last name B-A-C-K-L-E-R.
All right, go ahead. Your witness.
Thank you. Good morning, Mr. Backler.
Hi.
Sir, on November 21 of 2021, where did you live?
Objection, relevancy.
Overruled. You may answer, sir.
409 Central Avenue, Waukesha, Wisconsin.
Okay, if you could just keep your voice up a little bit, please.
Oh, I'm sorry.
Yeah, that's maybe better if you scoot a little closer to the microphone. Okay, 409 Central Avenue, and that's in the city of Waukesha?
Correct.
Okay. Around the time of 4:49 p.m. on that afternoon of November 21, where were you?
Objection, relevant.
Overruled. You may answer, sir.
I was outside working around the yard, had my garage open.
Okay. Were you aware that the annual Christmas parade was going on that afternoon?
I was aware of it, yes.
Did you attend the parade, sir?
No, I did
Objection,
not.
relevancy.
Okay.
Overruled.
Around 4:49 p.m., what happened, sir?
Objection, leading the witness.
Overruled.
I heard some noise around on the east side of my garage, and I went to see what was going on, and I found the defendant on the side of my garage. I asked him, what in the effing hell is he doing?
Okay, so let's slow down a little bit. You heard a noise and you went to explore it, correct?
Correct.
And you saw a person there,
Yes, I did.
and you questioned that person for being there. Is that right?
Objection, leading the witness.
Foundational, Your Honor.
This is overruled. You can answer. I'm not sure if you did or not.
I asked him what he was doing there.
Okay. And maybe you were cursing at him? Is that what you're suggesting?
Objection, leading the witness.
Overruled.
I think I dropped an F-bomb on him.
Why?
He's trespassing.
Okay. The person that
There
you
was an objection, but it's overruled.
saw, can you give us a description of that person, please?
When I called it in on the non-emergency line at the Waukesha Police Department, I described him at about 5'8", probably weighed about 150 pounds. He was either black, mixed, or Latino male, wearing a red shirt, jeans, long hair, beard, and I think he was missing his shoes.
Okay. You said red top?
Red shirt,
Objection,
yes.
leading the witness.
Red shirt. What kind of shirt?
Overruled, and his answer may stand.
He was wearing a red chino.
If there is an objection, please just wait until I rule on it first by saying either overruled or sustained, and I'll let you know if you can answer the question.
Okay, I'm sorry.
That's okay. Go ahead.
I believe it was a red T-shirt.
Okay. To your way of thinking, was he dressed appropriately for the weather?
Objection, leading the witness.
Overruled. You may answer.
Relevancy, objection.
Overruled.
Immediately, it just seemed off because he was wearing a T-shirt. If I remember correctly, he was not wearing shoes. It was very cold out. He was sweating. His eyes were huge, and he was just acting. When he came out from the garage, he was asking if I could call him an Uber.
Okay. So you spoke with him a little bit?
Objection, leading.
Sustained as to the form of the question. Please rephrase.
Very shortly.
I have to ask him
She
the
needs to
question.
rephrase her question.
I'm sorry.
That's okay.
Did you speak with him?
A little bit.
Okay. What do you remember him saying?
He kept asking if I could call him an Uber, and then he said I need to get home.
Did you agree to call an Uber for him?
No, I said I needed to leave my yard.
Okay. And did he comply with that?
Yeah, he did. He just kept asking if I could call him an Uber, if he could use my phone. I said, you just need to leave. And
The person that you're describing for us, sir, do you see him present in the courtroom here?
he's sitting over there with the mask on and in the suit.
Okay, I'm going to ask the defendant be instructed to remove the mask.
Mr. Brooks, please remove your mask.
And if he would look at the witness, please, Your Honor, with his head down, it's not to assist.
All right, Mr. Brooks, please look up and look at the witness. Look at the witness, please. Thank you.
Is that the man that you're describing that was in your backyard that you spoke to?
Objection,
Yes.
leading.
Overruled.
I want to show you a photograph. It's going to come up on that screen there next to you, okay? Just let me know when it's up. The system takes a minute to warm up, especially first thing in the morning. Is it up?
Yep, it is.
Okay. Do you see this photograph, sir?
Yes.
Objection.
And
Overruled.
Yes.
I'd like you, is there a person shown in the photograph?
It's the
Objection,
defendant.
leading.
Overruled. It's not leading. You may answer.
It's the defendant.
Is this consistent with his appearance when he presented himself to you on your driveway that evening or backyard garage area?
Objection, leading.
Overruled. You may answer.
It is consistent.
Okay. Move to admit and permission to publish 171, Your Honor.
Objection, relevancy.
Your objection is overruled. Exhibit 171 is received. Permission to publish is granted. The jurors will also let us know when the image is projected in the jury box.
And sir, it's a little hard to tell in the photograph, but was the t-shirt he was wearing a short sleeve or long sleeve, if you remember?
Objection, relevancy.
Overruled.
It was a short sleeve shirt.
Okay. Ultimately, did he leave your property?
Objection, accident, answer.
Overruled. You may answer.
When he was leaving, he was kind of taking his time, and then I told him he needs to leave again and started walking towards him as he was leaving, and he lifted his shirt up and said he was unarmed.
Okay. Had you asked him about any weapons?
I had
Objection, relevancy.
Overruled.
not. I had not asked.
When he left your property, did you see which direction he headed?
He was going northwest.
Okay. Thank you, sir. I don't have any other questions.
All right, sir. Mr. Brooks, do you have any questions for this witness?
Yes, I do, and I object to being called that name for the record. Do you recall giving a statement to Officer Probst?
I don't know his name, but I've talked to an officer.
And you did talk to an officer that night?
I talked to an officer on the phone. I did not talk to an officer that night. I mean, on the phone I did, but not in person.
So it was a conversation on the non-emergency line. Would that be fair to say?
It was on the non-emergency line. I actually confirmed it after I called to make sure I was on the non-emergency line.
Do you recall the description that you gave at that time?
I do. Well, my best of my knowledge was that you were either black, Latino,
Who's you?
or mixed.
Who is you?
Hold on, you have to let him answer the question first before you interrupt him with another one. Go ahead with the description you provided that night.
I said that the individual was either black, mixed, or Latino.
So it would be fair to say you didn't know at the time?
I was giving a general description.
So it would be fair to say that you weren't sure?
I was positive it was you.
Who is you?
You. I'm looking at you.
And how did you come to that conclusion, the you conclusion?
I'm looking at you.
How did you come to that conclusion? Did you
What conclusion? Can you restate the question?
You're saying that you gave a description on the non-emergency phone line, correct?
It was on a non-emergency line.
So it would be fair to say at that time you had no name or knowledge of who the person was in your backyard. Would that be fair to say?
I had no idea who you were.
And so how can you say how can you say you then if you had no idea?
I'm looking at you. You were the guy.
And how did you come to that conclusion?
You and I were standing in the same yard looking at each other.
So is it possible you saw something on the news?
No, I had no idea who you were.
Interesting. Do you recall giving a description of approximately 5'9" and 160 pounds?
Yeah, something like that.
Something like that, or would that be accurate?
I didn't have a tape measure out. It was just a guesstimate.
Would it be fair to say that since you keep identifying me as you, would it be fair to say that I'm not 5'9" nor 160 pounds?
You have your shoes on or off right now?
Would it be fair to say that I'm not 5'9", 160 pounds?
If you take your shoes off and step out of them, they could have a better.
Well, I'm not going to have them do that, but if you're able to answer the question, do you agree?
I'd
or
have to be
disagree?
standing next to him. That's what I made my judgment from. We were about 2 feet from each other.
Does it look like I'm 5'9"?
I don't know. We were a lot closer.
Does it look like I'm 160 pounds?
Objection.
Grounds.
It's irrelevant as to his appearance today, just like his hair isn't in dreadlocks today.
Sustained.
Objection.
Next question.
Grounds for the sustain.
Next question, please.
You also said that, well, the narrative in the report said that the individual was later identified. Would that be fair to say?
Yeah, that'd be fair to say.
And so would it also be fair to say that because the individual was identified later, that's how you came to the conclusion of who it may have been in your yard?
Objection, I think that's
Grounds.
a statement, Your Honor. He's, again, reading a police report,
That's a question.
not authored by this witness. It's beyond the scope of the witness's knowledge.
It's actually the report that he
Mr.
gave.
Brooks, I've heard enough. If the objection is sustained, you may rephrase your question.
Did you follow the investigation after you had given the report on the non-emergency line?
It's kind of hard not to see it on TV. Can I clarify something? Or?
There's not a question just
Oh,
yet,
okay.
so
All right.
the state will have an opportunity to redirect if they deem it appropriate.
Okay.
Thank you.
So you made reference to it was kind of hard not to see it on the news. Would that be fair to say?
He was all over the news.
And would it be fair to say that from those news reports you gained additional information that you didn't have that night?
Actually, what I did is went into work the next morning and pulled up the police report on the internet, and there you were in a mugshot. And I'm like, that's the guy.
So you got a further description from a mugshot?
No, I didn't get a further description. At the time, I didn't care who you were when you were in my yard. I didn't know who you were, what you had done, where you had been, any of that stuff.
So
Let him finish.
All I'm saying is you were trespassing in my yard at that time. And that's all I can say. Other than that, that's all I can confirm. I don't know what you did. I don't know where you were. I don't know any of the other stuff. All I know is you were the guy in my yard.
The guy that you said was 5'9", 160 pounds.
Objection, argument.
Grounds.
Asked and answered.
Grounds.
Sustained. Next question, you don't have to answer that.
And what prompted you to read or pull up the police report?
Objection, irrelevant.
Grounds. He said it. He brought it out there.
Overruled, he may answer.
I was curious of actually who you were.
And
And
what,
if you were the person that actually had done the atrocities that were on television.
And what prompted the curiosity?
A stranger was in my yard, unannounced, trespassing, asked them to leave, and they ended up catching somebody for doing something very bad, and I was wondering if that was the individual that had cut through my yard.
So it'd be fair to say at the time you wasn't privy to that knowledge yet. Grounds.
Sustained as to the form of the question.
At the time you pulled up the police report, as you say, you had no knowledge of the identity of the individual.
I didn't know that you were going to be the person that had done that.
You keep referring to the you.
You. I'm looking into your eyes right now. You're the guy I'm talking about when I refer to you.
And the record should reflect that the witness used his right hand and index finger to point directly at the defendant. Next question, please.
So you just made reference to looking the you in the eyes, but you would need...
What would you prefer I call you?
You would need...
Because you're not going by Darrell Brooks.
You would need me to step out of my shoes to tell my height and weight, right?
Well, I'd have to also stand 2 feet from you.
Hold on, please. Mr. Brooks, you're directed under 90611 to ask a question and not argue with the witness.
That
Thank
was
you.
the question.
It was argumentative. Please rephrase your question, and then the witness is instructed to wait until a question is asked. And if there's any objection, then I rule on it first. Go ahead, next question.
It sounds like he the one arguing.
Jury will disregard that last comment. Mr. Brooks, you're not testifying right now. You'll have an opportunity if you choose to do that later. Please ask a question.
Yeah, I'm going to get to it. Any reason why you didn't give a written statement to law enforcement?
Objection, argumentative, irrelevant.
How's it argumentative?
Sustained as to the form of the question. Next question, please.
Did you at any time give a written statement to law enforcement?
I don't believe so.
Any reason why not?
Objection,
Grounds.
argumentative and irrelevant.
Sustained.
Grounds for the sustain.
Mr. Brooks, please ask your next question.
Grounds for the sustain. You said you pulled up the police report at work the next day, right?
No, I pulled up your mugshot.
Well, you did say police report. Would that be fair to say?
You can answer that.
I just pulled up a mugshot.
You don't recall saying that you pulled up the police report specifically?
I specifically wanted to pull up the picture of the person that had committed those atrocities to see if that was the person that had cut through my yard, which confirmed it was.
And did you pull up the complaint?
No.
Have you ever seen the complaint?
I don't believe I have.
Have you yourself filed a complaint?
Nope.
Any reason why not?
Objection,
Grounds.
relevant,
Sustained
argumentative.
as to the form of the question and on relevance. Next question.
Do you recall who subpoenaed you to testify here today?
It's on the subpoena.
You don't recall?
I'd have to have the subpoena with me to read the name.
Do you recall if it was the district attorney's office?
It was.
Do you recall about how long ago you received the subpoena?
You can answer that.
A month or two ago, a couple months ago. I got a subpoena, so that's all I know, and I had to show up at a certain time.
So you knew it was a possibility that you would be called to testify?
I had no expectation of the subpoena until I went to the DA's office.
So you went to the DA's office?
They want to know. They ask. They want to see if you're worth having as a witness, or if you actually had any information that was pertinent to the case.
And so would it be fair to say that you felt that you did?
I didn't know.
Grounds?
Hold on. I'll sustain as to the form of the question that strike the last response. Please rephrase.
Did you feel that you had information that would be relevant to the matter?
That's an irrelevant question,
Grounds.
Your Honor.
Sustained. Next question, please.
Grounds for the sustain, Your Honor.
Next question, please.
Grounds for the sustain, Your Honor.
Next question, please.
Is that a judicial determination, Your Honor?
Ask your next question, please.
When you went to the district attorney's office, do you recall whom you spoke with?
There was 3 or 4 people there. I don't recall their names. I recall their faces.
You said you do recall the names, not the faces?
No, I recall their faces, not their names.
Oh. Do you see any of those district attorneys in court here today?
I see one district attorney and one officer was in the room.
And for the record and for the jury, can you identify whom you're referring to?
I'd have to point.
I'll
Her,
stipulate,
yep.
Your Honor, I met
And
with Mr. Backler.
this officer here, sitting behind them.
All right, so the
Yes,
witness has
Detective.
pointed to District Attorney Sue Opper and Detective Casey.
And that was around the time you first received the subpoena?
It was the time that the subpoena told me to show up.
Do you recall ever being told about the plaintiff in this matter?
Objection,
Grounds.
vague.
Sustained as to the form of the question.
Do you know who the plaintiff is in this matter?
Objection,
Grounds.
vague, beyond the
Grounds.
scope of the witness's knowledge, legally inaccurate.
Sustained as to the form of the question.
Did Attorney Opper ever tell you who the plaintiff was in this matter?
The subpoena told me who the plaintiff was.
And do you recall who the plaintiff is?
Darrell Brooks.
That's the plaintiff?
Or not the plaintiff, the plaintiff is, I think, City of Waukesha or State of Wisconsin. I'm not sure.
And it'd be fair to say that that's not a living, breathing human being.
Objection,
Grounds.
relevance.
Sustained, not relevant. Next question.
Are you aware that only a living, breathing human being can make a claim?
Objection,
Grounds.
irrelevant, argumentative.
Grounds.
Sustained for those reasons, and it's also not an accurate statement of the law.
Definitely not
Yes.
argumentative.
Mr. Brooks, under 90611, I need you to move on from this topic and ask a different line of questions, please.
Move on from what topic, Your Honor?
Next question, sir.
Can I know what topic you're referring to, Your Honor?
Next question, please.
If I don't know the topic, how would I know to go in a different direction?
Mr. Brooks, under 90611, I need you to ask a question.
Do you know if there's even a plaintiff in this matter?
Objection, irrelevant.
Sustained. Under 90611, sir, please move on from this topic or I will declare your cross-examination closed.
Under what law and fact, Your Honor?
Under 90611, please ask a question.
And where can I find 90611?
This is your last opportunity to ask a question, sir.
Your Honor, the jury deserves to know this information.
All right, then the state, any redirect?
No redirect. Thank you, Judge.
All right, thank you, sir. You may step down.